This morning, precisely at 10:03 a.m. Eastern Time, the United States Supreme Court issued a devastating ruling, a single sentence that effectively shut down the last possible exit in this extraordinarily significant case. The words were blunt: application denied. No lengthy legal reasoning, no detailed opinions from the justices, and notably, not a single dissent. This decisive action by the highest court in the land abruptly ended months of complex legal maneuvering, and it did so with a timing that is nothing short of surgical. This ruling arrived exactly 72 hours after Melania Trump's legal team presented a proffer agreement to federal prosecutors. This document is a seismic shift in itself, outlining the specific evidence she is prepared to provide in exchange for potential immunity. Think about the gravity of that, two massive legal events occurring just 72 hours apart. The timeline alone reveals how tightly coordinated these developments have become. Now, before anyone dismisses this as mere tabloid drama or sensationalist news cycle hype, I need to be absolutely clear about what we are looking at. We are talking about formal court filings, official proffer agreements, and binding Supreme Court orders. These are public records, not anonymous leaks or behind closed doors rumors. These are documents you can verify. What is now legally binding is this: Melania Trump has voluntarily waived marital privilege. This is the crucial legal protection that usually prevents prosecutors from forcing a spouse to testify against their partner. She isn't being forced. She is choosing to step forward. The evidence she is offering falls into three categories that could fundamentally alter the course of this prosecution: financial documents, communications, and witness testimony. The Supreme Court's final rejection means there are no more appeals left, no more delays, no more procedural escape routes. The grand jury is now cleared to hear her testimony within a matter of days. To put this into a broader context, the confirmation hearing for her former husband as a cabinet nominee is scheduled for early March, just 6 short weeks away. The sequence of events over the last 3 days was not random. On Monday afternoon, her attorney submitted the proffer agreement to the special counsel's office. In simple terms, a proffer is a preview. The witness says, "This is what I know, this is what I am willing to say under oath, and this is the evidence I can provide." In return, the government considers protection from prosecution. What makes this extraordinary is the identity of the person making the offer and the nature of the evidence being presented. Exactly 24 hours later, on Tuesday, the defense team filed an emergency appeal to the Supreme Court to block this testimony, claiming it violated marital privacy under the Fifth Amendment. The speed of that filing, prepared in just 1 day, proves the defense knew this was coming. By Wednesday, the court docketed the case, but pointedly refused to issue a stay. A stay would have frozen the process. Without it, the clock kept ticking. This silence from the court was the first signal of what was to come. Usually, when the Supreme Court sees merit in an emergency argument, they halt proceedings immediately. Their refusal to do so signaled deep skepticism. Then came the final blow this morning: a unanimous rejection. Even the justices appointed by the defendant himself did not dissent. In my 30 years of following legal proceedings, a one-sentence rejection usually means the court found the argument to be legally frivolous, so weak it didn't even merit a written explanation. The court has removed the final stall tactic, and the timeline has now shifted into high gear. This isn't just a legal update. It is the moment the system refused to be manipulated any longer. Now let's dig into what is actually inside that proffer agreement, because the evidence Melania is offering is far more severe than the headlines suggest. This agreement details 3 specific categories of evidence that, when combined, create a truly devastating legal picture. The first category involves financial documents that demonstrate direct knowledge of fraudulent valuations. She signed joint tax returns from 2014 to 2020. That is 6 years of tax filings where both spouses sign under penalty of perjury, certifying that the financial information is accurate. These returns rely heavily on asset valuations, what the properties are worth, the income they generate, and the deductions applied. If those valuations were inflated when presented to banks for loans, but deflated when reported to tax authorities to reduce liability, that constitutes both bank fraud and tax fraud. A signature on a joint return creates a shared legal risk for both signers. The proffer agreement states that she was present in meetings with accountants where these asset values were discussed, and she even asked specific questions about how the properties were being reported. All of this is documented in emails that prosecutors now have in their possession. The second category is communications. This includes text messages between her and the defendant discussing property values immediately before meetings with lenders. It includes emails with accountants where she questioned the discrepancies between what the banks were being told versus what was being reported to the IRS. And most significantly, it includes recorded phone conversations where specific property values were discussed in the context of loan applications. Let me be clear about what recordings mean in federal cases. If she recorded these conversations in accordance with consent laws, those recordings are admissible. If she is offering them in a proffer, the prosecutors have already meticulously verified their authenticity. The third category is witness corroboration. She can confirm what accountants and bankers have already told the grand jury under oath. She can verify the testimony of property appraisers who claimed they were pressured to inflate numbers. In federal cases, corroboration is the holy grail. If one witness says, "I was in a meeting where fraud was discussed," that's strong. If a second witness confirms it, it's stronger. But if a third witness, the spouse, produces documents and recordings from that same meeting, it creates a pattern of evidence that is nearly impossible for any defense to overcome. Here is the real legal earthquake. She is voluntarily waiving marital privilege. In most cases, a spouse cannot be forced to testify against their partner to protect the sanctity of marriage. But, and this is the crucial part, that privilege belongs to the witness, not the defendant. Her proffer agreement explicitly states that the privilege is waived for all matters covered in the agreement. This isn't prosecutors twisting her arm. This is her choosing to cooperate. I've seen spousal cooperation in organized crime cases where wives testified to protect themselves, but we have never seen this at a presidential level. This is the first time a spouse of a former commander-in-chief has come forward with financial records, communications, and direct testimony. The Supreme Court's unanimous rejection of the defense's appeal tells us everything we need to know. The defense argued that her testimony violated marital privacy, but 150 years of precedent, specifically the 1980 case Trammell v. United States, says the witness spouse controls the privilege. If she wants to talk, he cannot stop her. They also claim she was coerced, but her own lawyer filed an affidavit stating she initiated the contact with the special counsel's office. There was no subpoena, she reached out. Finally, the argument that this creates a dangerous precedent failed because the law applies to everyone equally, regardless of status. By issuing a one-sentence rejection, the Supreme Court signaled that these arguments were frivolous. The final stall tactic has been removed. The system is moving forward, and it is moving fast. So, why did the Supreme Court reject this appeal with such overwhelming force? The defendant's emergency filing presented three primary legal arguments, and I want to show you exactly why each one collapsed under the weight of existing law. The first argument was that spousal testimony violates marital privacy protections under the Fifth Amendment. However, there are 150 years of Supreme Court precedent establishing that marital privilege can be waived voluntarily. The landmark case Trammell v. United States in 1980 settled this once and for all. It held that the witness spouse, in this case Melania, controls the privilege. This means the decision to testify belongs to the witness, not the accused. If the witness chooses to waive that privilege and cooperate, the defendant has no legal standing to stop them. That precedent has never been overturned, and every circuit court in the country follows it. The defense's argument quite literally had no legs to stand on. The second argument was that the proffer agreement was obtained through coercion, threats, or heavy-handed prosecutorial pressure. They tried to claim the testimony was involuntary, but here is the problem. The filing included a sworn affidavit from Melania's own attorney stating that she initiated the contact with the special counsel's office. Her lawyer reached out, proposed the cooperation, and negotiated the terms. No subpoena was ever issued, and no threats were made. The proffer was her decision. Federal courts have a very clear standard for voluntariness. If the witness approaches the prosecutors on their own, the coercion argument is dead on arrival. That affidavit completely dismantled the defense's claim. Their third argument was a reach for public policy, claiming that allowing this testimony would destroy the institution of marital privacy in future cases. But again, that precedent already exists. Spouses testify in federal cases all the time when they choose to. What the defense was really asking for was a special exception because of who the defendant is, but the Supreme Court does not create exceptions based on identity. The law applies equally to a citizen or a former president. When the court issued that one-sentence rejection with 0 dissents, it sent a clear message. These arguments weren't just weak, they were frivolous. So, what happens next in the courtroom? The timeline has just accelerated dramatically. With the Supreme Court appeal denied, the grand jury can hear her testimony within days. In the Southern District of New York, the grand jury typically meets on Tuesdays and Thursdays. If the prosecutors are ready and the detail in the proffer suggests they are, I expect her to appear within the next week. Once that testimony is locked in, the special counsel faces a massive strategic choice. They can either use her testimony to supercharge the existing 34 counts of falsifying business records, or they can seek a superseding indictment with brand new charges. I am watching this very closely. The proffer mentions a March 2020 phone call she witnessed between the defendant and a banker where property values were discussed right before a loan application. If they both knew those values were false, that is a conspiracy to commit bank fraud. Conspiracy is a separate crime from the fraud itself. It's an agreement between two or more people to break the law, followed by an overt act. A phone call where they both knowingly lie to a bank is the agreement. Filing the loan application is the overt act. If prosecutors believe they can prove this through her testimony, the defendant's legal exposure just doubled. The trial is set for September 16th. With the Supreme Court removing the final roadblock, there are no more emergency motions or privilege claims left to litigate. That date is now set in stone. This is no longer about if a trial happens. It's about how much more evidence will be presented when it does. Finally, let's look at why this matters far beyond a single courtroom or a single defendant. This case is setting 3 precedents that will reshape federal prosecutions for decades to come, and I want to break them down because the ripples of this decision go much further than you might think. The first precedent is the reality of spousal cooperation at the highest levels of government. Historically, we've seen spousal flips in organized crime cases. In the 1980s, the wives of figures like Sammy the Bull Gravano or Henry Hill, whose life inspired Goodfellas, testified against their husbands to avoid their own charges. We saw it again in the Enron scandal, where spouses of executives cooperated after realizing their financial exposure was shared. But we have never seen this at the presidential level. Having a spouse of someone who held the highest office in the land step forward with financial records, text messages, and direct testimony is brand new legal territory. It changes the calculation for every future investigation into powerful officials. Prosecutors now have a clear roadmap. If a spouse has joint exposure because they signed documents or attended meetings, marital privilege is no longer an impenetrable shield. It can be a bridge to the truth. The second precedent is the speed of the Supreme Court's response. By issuing a one-sentence unanimous rejection, the court has effectively put an end to using spousal privilege as a delay tactic. Defense attorneys have often used these claims to drag out cases for years, hoping to outlast the prosecution or wait for a change in the political climate. The court's application denied message signals that once a witness chooses to waive their privilege, the legal system will not allow emergency appeals to clog the gears of justice. This is a massive win for judicial efficiency in white-collar cases. It tells every future defendant that the highest court in the land will not entertain frivolous privacy claims if a witness is ready to speak. Finally, there is the precedent of accountability regardless of status. For decades, the public has been frustrated watching wealthy and powerful defendants use their resources to paper the courts with endless motions and claims of privilege. This case shows what accountability looks like when the system refuses to be gamed. The judge maintained a strict timeline. The Supreme Court acted decisively, and the grand jury process continued without interruption. The court essentially said, the law applies to you exactly as it applies to everyone else. So, where do we go from here? With the grand jury likely hearing this testimony in the coming days, the real question is whether this leads to brand new conspiracy charges that could push the trial even further into the national spotlight. Based on the timeline I've shown you, do you think this testimony is the smoking gun the prosecution has been looking for? Or is it just about closing the loop on existing charges? Let me know your thoughts in the comments. And if you want to keep following this case without the media bias, make sure to subscribe. I'll be here to break down every filing as it happens.